Hello, everyone. This is Richard Capone from Let's Go Learn. I want to welcome you all to the webinar. Thank you for joining the webinar today, and I'm the CEO of Let's Go Learn. Today, we're presenting the top 10 tips for IEP process leaders, hosted by Let's Go Learn and presented by Dr. Kurt Hulett, National Director of Special Education Services at Let's Go Learn. Recently, Dr. Hulett presented the webinar as a live session at the annual CEC conference in Portland. There was standing room only, and so due to popular demand, we're holding this virtual version today for everyone. Just a little housekeeping. If you have any questions during the webinar, you can go ahead and enter that into the panel on the right. There is a question section, and you can enter that in. You could also enter it at any point, and we'll collect the questions and answer them at the very end. Also, if the panel is hiding everything, there is a little orange arrow. You can click on that orange arrow and it'll slide the panel off the screen. So that way you could have the full real estate to watch Kurt's slides. And then if you need to slide it back, again, you hit the orange arrow. Okay, without further ado, I'd like to introduce our presenter today, special education expert, Dr. Kurt Hulett. Dr. Hulett, let me just give you a quick background on Dr. Hulett. He's been a lifelong advocate for children with disabilities. He's worked at many different schools and companies promoting special education, and it was a real honor for us to have him today. Dr. Hulett?
Yeah, thanks so much, Richard. Super excited to be here with everybody. First and foremost, just want to send a shout out to all the educators out there right now trying to figure out how to educate children in this environment of chaos, at least educationally speaking. I've never seen our world change so rapidly in just a matter of days. So to all of you trying to figure out how to best meet the needs of all your kiddos, thank you for what you do, and hold strong, and just know my blessings and love are with you. So without any further ado, what I'd like to do before we get going here on the top 10 tips is just tell you a little bit about Let's Go Learn. And the work of LGL falls into basically two main buckets. One, LGL provides diagnostic adaptive testing in reading and mathematics for grades K through 12. These data are used to write high quality IEPs and direct instruction. Once a child is diagnosed, the LGL system prescribes 60 individualized lesson plans based on student needs. In addition, the LGL system helps to create PLAFs and goals and has an engine to progress monitor each goal on a weekly basis. Second, and where I come in quite a bit, LGL provides extensive PD in the area of special education. Right now, we are supporting a number of schools trying to figure out how to provide online instruction at home. That's something we specialize in. And providing specialized instruction during this time is quite a challenge. So I'm excited to work with a company that is right in the middle of the struggle right now and trying to help and support folks out in the field. So we're going to jump right into it here. Many of you veteran educators will remember the Rallye Standard. We need to kind of establish where we are and where we came from. The Rallye Standard, as you guys know, essentially established a really low bar going all the way back to 1982 for what the field of education had to provide kiddos. And essentially you had parents of a young girl with hearing impairments argued that FATE standard was to ensure the child received the best possible education. The High Court disagreed and indicated some educational benefit was required. The court said since she was already doing well, she didn't need a one-to-one interpreter. Over the next decades, multiple courts of appeal came up with various interpretations of some educational benefit. And yes, I'm using air quotes as I say that. The different interpretations included terms such as meaningful educational benefit, some educational benefit, more than trivial educational benefit, and my not so favorite, merely more than de minimis educational benefit, which basically means merely more than nothing. As you can see, a very low bar of expectation was set for special education. Now, we advance all the way up to present day. And in 2017, we had quite a shift in focus with the Supreme Court. And basically, we, due to splits across the country of federal courts of appeal, the Supreme Court agreed to hear the case. And upon granting review of the 10th Circuit's merely more than de minimis standard, the Supreme Court unanimously rejected it as one bar set too low and noted, quote, when all is said and done, a student offered an educational program providing merely more than de minimis progress from year to year can hardly be said to have offered an education at all, end quote. So the Supreme Court set forth the following clarification, and this is really key to hear and understand. To meet the substantive obligation under IDEA, a school must offer an IEP reasonably calculated to enable a child to make appropriate progress in light of the child's circumstances. So a couple key terms here: reasonably calculated. How was it built? Is it built well? Is it a good IEP? And then to make progress, gang, we now have to demonstrate progress. The days of just marking P in the IEP are over. We need to have measurable data to indicate that a child is making gains within their goals. And in light of the child's circumstances, so this is really unique. What it's saying is that progress for one child may look different for another. So you take a child with an IQ of 50 or 55, and who's in a life skills program, and their progress in, say, reading may look different than a child with an IQ of 110 who has dyslexia. It could look different, and that they want these unique circumstances to be taken into account. So what that brings us to is a two-part test that hearing officers in courts now use today. The first part really relies on the Rallye Standard, which just says, did you follow the rules? Did you follow the process? Did you check off the boxes? Did you do it within the amount of days you were supposed to? And did you invite the right people to the meeting? So again, did you follow the process? The second part is where Andrew F comes in, and it gets a little bit more significant, in that it says, if you did follow the rules and the procedures, is the IEP reasonably calculated to enable the child to make progress appropriate in light of the child's circumstances? So again, the content piece is what was adjusted by the Andrew F ruling. So this is super critical language to be aware of and to really know what's expected by the Supreme Court. So let's hop into some of our basics here of process. And so I like to use the word anointed because it is not, it's a little ironic, because quite often being the LEA rep is not in a distinction of honor. We don't all want to be in that position. It's a position of great responsibility. And basically, you have to have an LEA rep at every single meeting. And let's jump forward a little bit and see what the qualifications are for an LEA rep. The first three you'll see here, you can find in your federal regulations. The fourth one was provided in guidance by the US DOE. But you'll notice the first three here are really easy and they have low bars. So the LEA rep has to be qualified to provide or supervise the provision of specially designed instruction. So anybody with an educational license can basically fit this. Is knowledgeable about the general curriculum. Yep, as long as you work in a school and you have an educational license, you can probably meet that. Third, is knowledgeable about the availability of resources of the public agency. Again, not particularly difficult to demonstrate that you have general knowledge of the resources. But this is where it gets a little trickier. The fourth one, the LEA rep must have the authority to commit district resources and be able to ensure that the IEP will be implemented. So this one is where I think some districts could get in trouble. If you have a guidance counselor or an assistant principal as the LEA rep, I could argue pretty well that most assistant principals and most guidance counselors do not have the authority to commit a one-to-one aid or other major resources that would commit financial resources to the district. Some districts do this well, but be very cautious about who you put in these roles and make sure they have legitimate authority to make decisions. Now, who has to be at these meetings? We all know these pretty well by now, but let's review them just to make sure from a process standpoint we're in good stead. Mandatory school-based members, one regular ed teacher, one special ed teacher, the qualified LEA rep we just talked about, and then somebody that can interpret evaluation results. And this is really key, y'all. We can excuse teachers and members of the IEP team, but I really discourage continuing with an IEP meeting if you do excuse. And remember, you need it in writing, and the parents need to agree in writing. I've been in more IEP meetings where the school district just says, oh, hey, mom, dad, the bell's about to ring. Do you mind if Miss Smith goes back to class? Oh, sure, no big deal. Well, you could have just opened yourself for a wonderful faith violation argument down the road. So be very careful. Make sure you have the requisite people at these meetings and they stay at the meeting for the entire time. So Pitchford v. Salem Kaiser School District. This one is really important because it is a FAPE violation, but why? They had real quality IEPs in 96, 97, 98, 99, and 99, 2000. However, the 97-98 school year was sufficiently flawed to find a denial of FAPE because no district rep attended the meeting who was qualified to provide or supervise the provision of special ed services. So basically you have 4 years of quality programming, and they basically find, essentially a loophole where there was this one meeting where the one person didn't attend, even though they had had success before and after this. And that was found to be a FAPE violation. So again, you've got to have the right people at the table. Tamalpais Union High School District, 2015, FAPE violation. This is where the school team members said that they did not have the authority to do anything with the parents' request to fund a transition program. This was a procedural violation that denied FAPE because it interfered with the parents' rights to participate in the IEP process by limiting the parents' request for additional services they desired. The ability to commit resources is inherent in the role of a district rep who has the ability to make financial decisions on the district's behalf. Remember, guys, don't ever say, if you're the district rep in particular, you don't have the authority to commit a resource. Just simply say you disagree with what they're requesting. This is a really important piece to remember. Never ever say we can't afford that. Now, gang, finances in unique circumstances can be taken into account. But what's important here to know is that we don't want to go down this road. Just do not address, if somebody wants something that you find inappropriate, they want a Learjet, even in that circumstance, just tell them you don't find it appropriate. I don't have the authority to approve that. Well, if you're the LEA rep, you certainly do, and an IEP team has the authority. We need the director of special education here to make those decisions. No, the LEA rep has the authority, remember, to authorize these district resources. Now, what could you say if you were put into kind of a tough circumstance? Well, you could say at this time, the school members of the team do not see this service as necessary. You could say, we don't believe this service is necessary to achieve a FAPE for Johnny. This one I also like the most, I think, is at this point, we do not see this service as necessary. I recommend we convene this IEP and meet again in the near future after the school members have had more of an opportunity to research your request. That way, you're demonstrating or indicating you don't agree with it, and you have the right to not agree with it, but you're willing to research it and take time to look into it, which also buys you a little bit of time. Okay, tip number 1. Emphasize the importance of maintaining a good meeting invitation process before and after IEP meetings. I see a lot of errors made in this process. TSV Wiest, very famous case, no FAPE violation, multiple attempts to reschedule and include parents. So basically they moved forward with an IEP meeting without parents, but they worked extremely hard to get them there. So as long as you make, I always have a rule of 3 to 5, be willing to reschedule up to 3 to 5 different times and make sure you document your willingness to do so. But if the school district uses common sense and really does make efforts, then you're going to be in good stead. DBV Santa Monica Malibu Union School District, FAPE violation, exclusion of parents of deaf teen. Basically, the district's exclusion of parents constituted a FAPE violation for a deaf teen. The unavailability of certain IEP team members during the summer did not justify the district's decision to go ahead with the meeting in the parent's absence, and after they had asked for it to be rescheduled for a date when they would be available. So again, you've got to work with parents. The courts do not look upon well when you don't make every effort to include them. Board of Education of the Toledo City School District v. Horan, FAPE violation. The district denied a FAPE when it seriously infringed on the parent's opportunity to participate in the decision-making process by proceeding with an IEP meeting in their absence. Although the parents called to cancel the meeting, indicating that they would reschedule, but never did so, the district should have taken additional steps to reschedule an IEP meeting with them. So we're looking at taking more effort, more steps, and ensuring that every parent has every opportunity to attend. And again, the litigation shows it over and over and over. The courts will not side in your favor if you don't. Tip number 2, prepare adequately for IEP meetings. So what does that mean? There are a couple of my personal bugaboos in here. So meeting room and space. When the parents get there, don't be looking for your space. Make sure you already have a nice area. Let's not have it be the janitor's closet. A nicely furnished, nice area. Preparation and understanding of school staff roles. Make sure everybody understands their role. Are they the LEA? Are they special ed, regular ed? What's their role? Parent survey questionnaire. It's always good beforehand to get parent input. Greeters. Gang, make sure you identify greeters, people who are going to stand up, get up, whether you do hugs, handshakes, fist bumps, air slaps, whatever we need to do nowadays with the coronavirus. But at any rate, we need to greet our folks by standing up. Seating arrangements. Don't have 12 educators on one side and the 2 parents or the 1 parent alone on the other side. Again, make sure you're ready. You have everything printed out. Make sure technology is working. You shouldn't be trying to get the overhead working and your computer up and running. Again, this is just good, common planning for any event. And I see so often when schools are not prepared, and it just sets a negative tone for the entire meeting. Arlington Central School District v. DK and KK, FAPE violation, no regular ed teacher. Gang, I will tell you, if you don't have a regular ed teacher there, it's going to be a FAPE violation. The courts have showed over and over and over. MLV Federal Way School District, FAPE violation. Again, no regular ed teacher. And this goes for a regular ed teacher being there and then being dismissed at the very end because they need to get to class. Again, if you don't have it in writing and signed by the parents, you're putting yourself at great risk. So really make sure you get everything in writing as you move through this. While preparation is important, avoid the appearance of predetermination. Gang, this is a huge area that's growing almost by the day, where schools are being held accountable for planning too much in advance and predetermining the services and approaches for the kiddos. Remember, the IEP process is intended to have the parent input. So if you go in, make sure that you and your team are aware that this is a proposal and that you are open to adjustments based on parent input. So very, very important. JS v. New York City Department of Education, no FAPE violation. Preparation of a draft IEP for an autistic child did not violate FAPE. The district was able to prove that the final IEP had documented the parents' input and opinions. The parents' claim for private tuition was denied. So what's important here, gang, is you can have draft IEPs. What I recommend is that you very conspicuously leave certain components out, such as parent input. The notes, make sure, LRE, you can check that off when you get there. You can even add in components of the present level. Leave very open space that you have to add and fill in so that you have a documented difference between the draft IEP and the final IEP. That has shown in court cases to go a long way. AG v. State of Hawaii, 2015, no FAPE violation. Parents' argument that the district's reference to a workforce program constituted predetermination of placement was denied. The parents had ample opportunity at the IEP meeting to express concerns and give input. The IEP team modified the draft IEP with the parents' input and concerns. Again, gang, they had documentation, document. They left space in there to give the parents input, and then when they got challenged, it became very clear. And hopefully what you're also seeing from some of these cases is that the courts take into account just good practice and common sense. If you use good common sense, it tends to work out for the school district. Here's an example of not using common sense. Henrico County and Spielberg v. Henrico, they had completely predetermined everything prior to the IEP and made no bones about it. Of course, the courts found in favor of the parents in this case. This is a very famous one out of the Fourth Circuit. So let's pop over to tip number 4. Use efficient and effective tools and strategies when conducting the IEP meetings. I'm always surprised that to this day when I go into IEP meetings, it is not uncommon for them not to have an agenda. An agenda is your best friend, and it can take a lot of different forms. It can look different, but here's the thing. If you're dealing with a parent that's emotional and it's getting contentious, it's very easy to get off track and very easy to miss something extremely important. You need to have somebody designated as the administrator or the individual who's going to keep and chair the meeting and keep everybody on track. So an agenda really forces you to stay on track and makes you aware of what you have spoken and what you have not. It can also be used as documentation in legal proceedings if you put notes on the actual documents as to what was discussed, wasn't discussed, parents' input. So again, this is further example of documentation. So make sure you use these agendas. Tip 5, ensure the parents have received their rights and have been offered an explanation of them. We do this pretty well. Most parents could wallpaper their houses with what we've provided them. Couple areas to remember where schools do forget is, you need to do it upon the initial referral or parent request for an evaluation. We miss it there sometimes. Upon receipt of the first state complaint and upon receipt of the first due process complaint. If you get a complaint, make sure you send them a copy of their rights. The other piece is a lot of our parents don't understand it. So really take some time to offer explanations. I love rights nights, what I call them, where school districts will actually offer opportunities for parents to come listen and hear the procedural due process and parental rights explained to them in everyday language. Conway v. Board of Education of Northport East Northport School District, no FAPE violation. The parent could not prove that she never received her parent rights to file for due process hearing, where the evidence showed that the district provided such notice. So it's interesting, whoever brings the complaint, the burden of proof is with that person. But what I find is that schools always have to prove their innocence. So make sure you have the documentation so that you can clear your good name if ever challenged, just like this school district did in this case. James v. Newport News, Fourth Circuit, FAPE violation. Parents entitled to reimbursement for LOVA's program due to district's repeated failure to notify them of their right to a due process hearing, where the failure to comply with IDEA's notice requirements led to a finding of denial of FAPE. Court may award reimbursement for substantial educational expenses incurred by parents because they were not notified of their right to challenge the appropriateness of the district's program. Remember, it is so absolutely critical to make sure you get those rights to those parents. And you can see these are school districts that are paying a lot of money for these errors. Tip 6, allow for and guide appropriate participation of parent invitees. This is always a very interesting area to me because I think when we face advocates, when we face attorneys at these meetings, we often do not want them at the meeting, and it is easy to become short. It can be easy to dismiss them, but remember, they're there to represent the parents, they're there to represent the child. So their opinion does matter. And regardless if it's a minister, it can be a neighbor, it can be anybody that has special knowledge of the child. So make sure that you allow them to speak and to speak freely and to have an opportunity to participate in the meeting. These are just a couple letters of guidance that came from OSEP that just essentially say that outside individuals do have a right to participate. Okay, tip number 7, ensure the recommendations of outside evaluators are considered. So this is an area that gets missed quite a bit, actually, where there is either a private school evaluation, an outside evaluation. And here's what's important, gang. You have to consider all evaluations, all information, but you do not have to take action. So if a doctor sends you a note saying Johnny is autistic, he needs an IEP, and he must have ABA, you have to consider that. You do not have to accept that as gospel and do everything that that physician says, but you do need to consider it. So Mark M. v. Department of Education, Hawaii, 2011, FAPE violation. Although the parents of a child with ADHD waited until the very last minutes of an IEP meeting to share a private school progress report, that was no basis for the team to disregard it. The Education Department procedurally violated the IDEA and denied FAPE when it declined to review the private report. So remember, we have the two-part test. One is procedural, the other one is substantive. So this was considered a procedural error and a pretty major error that they made, and a very costly error that they made. And it would have been simple, just allow them to present this private report, but they learned a very powerful lesson in this case. Dubois v. Board of Education of Worcester County, no FAPE violation for procedural error. Even though school district procedurally erred when it failed to consider the evaluation by the child's physician relating to the need for extended school year services, this failure did not necessarily deny FAPE to the child. A violation of a procedural requirement of IDEA must actually interfere with the provision of FAPE and have a substantive impact before the child and or his parents are entitled to reimbursement for private services. So what's important here, gang, is it used to be if you didn't dot an I, cross a T, basically, you know, it was a FAPE violation. And then this got remedied, and essentially it has become that a procedural error has to have a substantive impact. Now, there are certain procedural errors, such as not having a regular ed teacher, that seems to trigger a FAPE violation almost every time. However, remember, if you make an error, the parents have to argue that it had a negative impact on them and violated their ability to receive a free and appropriate public education. Very important distinction there. Tip 8, keep all IEP team members focused on the I in IEP and IDEA and all IEP meetings. So often, gang, we've almost gotten too good at what we do, and we have too much IEP software, where I can't tell you the number of times I've seen the same language in IEP after IEP after IEP, and I've also seen the wrong names in IEPs because of copying and pasting. This is a surefire way to find yourself in trouble. And it becomes very clear when that occurs that individualization is not occurring. Remember that we also, every LD student doesn't get inclusion with extended time on tests. It's not the same for every child, and it can't be considered the same. So we need to really spend time considering the unique needs of every child and individualizing their needs. This is an area that with our current technology and current approaches, I really worry about moving forward. And there's nothing wrong with IEP software. We just have to utilize it appropriately, and we don't want to just do drop downs for every need because they may have different needs. So keep that in mind when you're writing these IEPs. Very famous case, DLV Hamilton out of the 6th Circuit. FAPE violation. District denied parents of a student with autism the opportunity to meaningfully participate in the IEP process when it placed their child in a program without considering his individual needs. Though parents were present at the IEP meetings, very important, they were there, their involvement was merely a matter of form and after the fact, because district had at this point, or at that point, pre-decided the student's program and services. Thus, district's predetermination violation caused the student substantive harm and denied him FAPE. Again, the procedural error caused a substantive error which denied FAPE. It appeared the district had an unofficial policy of refusing to provide one-to-one ABA programs because it had previously invested in another educational methodology. So what's really important about this one, gang, is I've come across a lot of districts that have unofficial, we don't do one-to-one aids. That's inaccurate. You have to consider any reasonable requests based on the needs of the child. Even if you disagree with it, you cannot have an unofficial policy that you just don't do this. So make sure your schools understand that you do not have unofficial policies, that everything's on the table for children when you're meeting their individual needs. So this is a super critical point to look at, and you can see the parents were even there at the time and it was still found to be a FAPE violation. So let's skip over to tip number 9. Use a consensus building approach to help the team make decisions. So, you know, the thing is, if you have a special ed director there or a senior administrator like a principal, just because they're the highest rank doesn't mean that they're the individual who's making all the decisions. Now, your LEA rep has to make the final recommendation if there is disagreement. But remember, it's supposed to be consensus building, not the parents just listening to what the school has come up with. And we tend to forget that. And I'm reminded of a funny story of a parent who thought it was a numbers game and a voting issue. So they brought 9 family members with them so they could outnumber the school. So that's not what I mean by consensus building. It's not a vote, and the school does have the final responsibility to put forth the educational program. But remember, we want to involve parents, we want to get their support, and we want them to be agreed members. We don't want disagreement if we can avoid it. So tip number 10, use an action plan or meeting minutes to document agreements made regarding things to do after the meeting. This is an area where, you know, we'll have this great IEP meeting, everything's going well. We get all sorts of great services, accommodations, modifications, assistive technology, everybody's excited. And then we break and we don't know who has to do what. So make sure there is a to-do list, whether it's in your, you know, your final minutes of the meeting, but make sure there is a plan that's going out and is going to be very clear in your deliberations who's going to be responsible for doing what. So here in a moment, we're going to turn it over for questions. I wanted to leave ample time for you guys. But before we hop into questions, I did want to tell you a little bit about something I'm really proud of. I get to do some product support and product development with LGL, and I was a collaborator on a recent report and tool that Let's Go Learn developed. And basically, it is an IEP report and tool. It cuts down IEP development by about 50% of the time because it gives you all of the information and narrative for goals and present levels. It's unbelievable with really helping with legal compliance. We've recently heard from multiple customers who had site visits from a state, and they got glowing remarks because they had been using this approach. And then it also has turnkey progress monitoring. This is brand new to where you're going to be able to progress monitor all of your IEP goals very rapidly. So just something I'm really proud of that we've done, and I've done in collaboration with the LGL team. Very exciting. But let me now pop over to questions. What questions you might have, or if you have any great insights that pop we're going, I'd love to hear them.
Well, thank you so much, Kurt. That was a wonderful webinar. So we have some questions popping in, and if you have a question, remember, go over to the right panel, and you can go down to the question section and enter in your question. If you don't see your panel, remember to click on that orange arrow and it'll slide it back out. So I'm gonna go ahead and ask the questions as they come in, and then let me go ahead and read this first one. All right, here's the first question. How does one plan appropriately without the perception of predetermination?
So great question, and and I know it's a little confusing because on one tip I tell you to plan, the other tip I tell you not to predetermine and not to have the perception of over planning. And essentially what you need to do is, as I mentioned a little bit earlier, the main thing you can do is leave open places in the IEP document so that you can fill them in during the meeting. So one of the things you will have is the draft IEP will have gaps, and then the final IEP that you lock and complete will have marked differences in the draft. And then there's your documentation of what was taken into account and that these issues were addressed and that parent input was taken into account. So that's my recommendation when it comes to that.
All right, super. Next question. Currently, one district has a designated teacher at each school who has been designated from the superintendent to be the ARC chair. They are not administrators in the district or the school. So I guess the question is, how does that impact things? Yes.
So that would give me some pause. Now, it is possible that that person could be an appropriate LEA rep, but they would have to have the authority to commit district resources. Normally speaking, if they're going to be the LEA rep, and I guess that's a distinction. If they're going to be the LEA rep, they have to have that authority. So maybe the superintendent is allowing them to make these decisions and has given them all of the knowledge of all the district opportunities. The other thing I've seen is where you have an IEP administrator who chairs the meetings, but they're not the LEA rep. I don't recommend, I'll be honest, putting teachers in those positions as LEA reps because they don't have the experience that administrators do of managing difficult circumstances, and the dynamics of an IEP can be very intense, and I just wouldn't recommend putting a teacher in that situation. So to answer your question, it is possible that it is legal and appropriate. Again, they would have to have that authority, but I would really shy away from that and try and have a principal in that role, or a former administrator who's in an administrative capacity within the district.
All right, super. We have a lot of questions, so let's try to go quickly. Here's the next one. In the Let's Go Learn system, if it provides data, how does the product help create or write a PLAF since it's not, since it's a written narrative?
So really cool. It actually produces written narratives. So in reading, it will tell you that, you know, Johnny struggles in these areas of phonemic awareness, phonics, vocabulary. He's strong. He has a grade equivalent of 4.8 in comprehension. It is, because it's diagnostic, it's able to generate narrative prose. It does it in math also. So yeah, you're able to get prose-based narrative present levels that are diagnostic. Great.
All right, next question. Aside from parent input, what other items do you recommend leaving off the IEP draft?
I like to leave, there's always a part for LRE considerations, and I really think it's best to consider that with parents. Another piece is, and this is a little different from just parent concerns, but the present level. I like leaving components out of the present level to add those in based on parent input and other educator input. And then of course the deliberations and the minutes are also where you can put in more parent input. But if you hit all those areas, you're going to be in a really good spot.
Super. All right, here's another good question. How would you address attendance of a general educator at an IEP meeting at a private day school where the staff is all special educators?
Okay, repeat that one more time.
So how would you address attendance? We're saying that you have to have a general educator at an IEP meeting, but what if the school, if all the teachers are special educators, there is no general ed teacher?
Well, if it's a private school,
Private day school.
a private day school, I mean, what a lot of groups will do is they'll partner with local public schools and actually borrow regular educators in those circumstances, because we're assuming they're held accountable to IDEA, and they're receiving some form of federal funds. So, what you may have to do is come up with some form of a partnership to get them there. But those are really difficult circumstances when you have day schools such as that, but you still need to attempt to get a regular educator there. Because the idea is that if they're in a private day school, they're in the most restrictive environment, and they really need to know what the expectations of the regular ed environment are. So I would try and get one there.
Okay, super, thank you. Next question. I like the tip about what you should never say. Can you provide some more can says?
Sure. The biggest thing that I think is really safe to say is when you disagree with something, because normally if you're going to want to deny something or say one-to-one, I'll give you an example. A lot of districts get requests for one-to-one aides, and they simply disagree that that is the most restrictive thing you can do to a child, is to give them a one-to-one. And in my experience, I think I've come across one circumstance where it was actually appropriate to do so, and it was a severe physical disability with a child who had wonderful cognition and needed support just to be mobile throughout the school. And this person needed a one-to-one. But in these circumstances, let's say somebody wants a one-to-one and you don't agree with it, just tell them you do not believe this would be the LRE. This is not appropriate. It would be the most restrictive, and we just don't find it appropriate. So when you disagree, just say you disagree. Just don't say we don't do that, or we don't approve that, or we don't authorize it. But be clear with your disagreement and be open and honest.
All right, super. Okay, this one's a long one, so listen carefully, Kurt. We have two problems with students who are formally labeled 2% students who are no longer able to participate in alternative assessments. These students are participating in general education curriculum classes and are not performing well. These students have difficulty with the curriculum. How do we individualize goals that are appropriate when these students are forced into classes that are far above their skills?
And that's actually, we put a report together to help educators with that very issue. And it's one of the problems with state testing and IDEA. I believe for a long time that a lot of state testing is inappropriate assessment, yet we force certain kids who are 4 and 5 grade levels below to now take it. And it's wholly inappropriate. So that being said, I think the key in these circumstances is to make sure that their goals are aligned to the general expectations of that grade level. And you have to tie it into those standards, even if the kid is 3, 4, and 5 grade levels below. And what I would say is focus on things such as, in reading, comprehension is the end-all be-all goal. In mathematics, real-world problem solving is the end-all goal. Now, if you look in any curriculum across the country, you're going to find word problem solving and comprehension is going to go through all of the different standards. So find those standards that are really reasonable to the kiddo and necessary, and get as close as you can, get grade equivalents, and make it clear where they currently are in their baseline, but where you're trying to get them to. And I do, believe me, I know exactly what you're dealing with, and it is so frustrating that we're put in those circumstances.
So Kurt, wouldn't it also be a solution for some of these general ed classes to maybe have some kind of rotational station learning as well, so that these students,
certainly,
right? Because not even students with IEPs, but even students who may be struggling in the regular general ed classes, they can get some personalized learning. Okay, so that's a structural issue then. All right. All right, here's lots of questions. So here's another one. This topic is very deep. Can you do more PD on this? And how many people can you train in what formats?
Yeah, we do quite a bit of PD. We've done as large as 100 people at a time. We can do, as small as you want, but we do a lot of areas. We do disproportionality. We do all of these topics. This is actually a part of an administrative training that we do. So yeah, we just work with the districts and try and figure out their needs. But our biggest push has been training building level administrators and district administrators, because they have such major leadership roles in special ed, and we've done a disservice over the years by not training them. So we're at Let's Go Learn, we're really focused on training them.
Great. This is a follow-up question. It says, what if the faculty at the special education school is a public school and there are no general education teachers?
Well, if it's
back to that question, yeah. If
it's a public school, so it would have to be a public school, but it's a special day school. So then you would have to basically have a regular ed teacher from another school come over within the district. And you know what a lot of groups do like that I've worked with, who are private day schools basically, is that they'll hold their IEPs on certain days, and basically they'll bring in a substitute regular educator who will be there all day, and they'll just run through all the IEPs in that day. And so that way you kind of maximize the use of them, but you would need to get a regular ed teacher in that curriculum. So let's say you had a child that's 12 but is cognitively working around the kinder level. They're in your school in what is essentially a kinder level class. You would want to get a 5th grade teacher in there to talk about the curriculum, even though it seems far off. That's where you want to move them toward, is that regular ed environment with their regular ed peers at their own age. So you'd have them come talk about the general curriculum, even if it's really far off.
All right, super. And also, this question is a very complicated question. So we do have Kurt's email address up there, and it might be helpful to arrange a separate telephone call, because I know sometimes it's hard to get your answer through,
Yeah. As Richard says, it's right there. So let me know. We can pick up the phone and talk through these issues, because I know sometimes it's hard to get the extent of the questions answered.
All right, here's another question. The Let's Go Learn program can it be used through a resource self-contained class, or can it also be used through a general education classroom?
Yeah, both. We have a lot of districts that use it for self-contained classes because you have a lot of prescriptive, individualized instruction for those kids. So that's real common in resource. And then we have a lot of small group station work that they use Let's Go Learn for in the regular ed classroom. Quite often they're inclusion classrooms, and the inclusion teacher is managing stations, and the kids work through it.
And we also have a separate webinar recording on using Let's Go Learn in inclusion, as well as a white paper on that as well. So we can go ahead and send that out to you. So by the way, everyone, we are going to be sending a recording of this webinar out to everyone who registered. And we can also include a link to the inclusion white paper too. So let's see. All right, it looks like that's the last question. So looks like we're done. Thank you, everyone. And as I mentioned before, we will be sending out the recording, and we'll be sending some other information. If you have questions, you could go ahead and send Kurt an email, or you could also send an email to help@letsgolearn.com. All right, Kurt, anything else you want to add?
Well, again, I just want to thank everybody and give them my best wishes. I cannot imagine the challenge that you all are facing right now with the coronavirus and the school closures. And just know I'm thinking about y'all, and more power to you, and best of luck out there.
All right, thank you very much, everyone.